Good morning, dear students. Today we will start video lecture 1.2 from Unit 1 relating to justifiability of fundamental rights. We must understand first of all what is the meaning of justifiability of fundamental rights. Justifiability means capable of being justified or understandable or reasonable, or that can be shown to be or can be defended as being just or right. In this lecture, we will see whether fundamental rights are justified or not, are they understandable or not, are they reasonable, or can they be shown to be or can be defended as being just or right. We have seen in the last lecture also, my dear students, that Article 13 gives teeth to fundamental rights. After Constitution came into force, the direction for the state is that the state shall not make any law which takes away or abridges the fundamental rights conferred by Part 3rd of Constitution of India, and if such law is made, it shall be void to the extent to which it curtails any such fundamental rights. So this is the Article 13 which confirms the justifiability of fundamental rights. And it goes to this extent that state is directed not to make any law which takes away or abridges the fundamental rights conferred by Part 3rd of Constitution of India. And if the state is making any such law which is violative of fundamental rights, then that law shall be void to the extent to which it curtails any of the fundamental rights. Dear students, if you read Article 13, Clause 1 and 2, you will come to know that these two articles are two touchstones to test the validity of any law, whether it violates any fundamental right or not. Article 13 Clause 1 और Article 13 Clause 2 ये हमारे पास पारस के दो पत्थर, पारस के दो पत्थर जिस पर हर कानून की वैधता को टेस्ट किया जाएगा. You see, when you go to a jeweler for selling your ring, he rubs your golden ring on a black stone, and the jeweler can easily find out the percentage of gold in your ring. Like jeweler, we have two touchstones with us, Article 13 Clause 1 and 13 Clause 2. These are the two tests on the basis of which we will find whether the value of fundamental rights is more or less. The value of fundamental rights given by the Constitution is high to such an extent that if any law is made by the Parliament which violates fundamental right, such a law shall be deemed to be void. We have so many examples where the law enacted by the Parliament was struck down or declared unconstitutional by the courts. These laws may be pre-constitutional laws or post-constitutional laws. Article 13 Clause 1 deals with pre-constitutional laws, and Article 13 Clause 2 deals with post-constitutional laws. Law has to pass the test of either of these two articles, and we have to see whether the law is not violating any of the fundamental right granted to us. So, first category of laws which can be tested under Article 13 Clause 1 and 2 are ordinary laws and ordinary amendments. All of us know that Section 303 IPC was enacted in 1860. Obviously, it is a pre-constitutional law, And this section was struck down in Mithu versus State of Punjab because it offends the fundamental right of life and liberty given in Article 21 of our Constitution of India. So this pre-constitutional law was declared unconstitutional under Article 13, Clause 1. Similarly, Section 66, capital A of Information Technology Act 2000. This is a post-constitutional law. This section provides 3-year imprisonment for sending offensive messages. This section was added in Information Technology Act 2000 by amending Act of 2009. And this Section 66A was struck down in Shreya Singhal versus Union of India as violative of freedom of speech and expression under Article 19, 1A, and it was not protected as reasonable restriction under Article 19, Clause 2. Next example again from IPC, Section 497 IPC 1860, again a pre-constitutional law, was struck down in Joseph Shine versus Union of India as violative of equality and violative of life and liberty. So now adultery is no more an offense. So 497 IPC 1860 is an example where pre-constitutional law was struck down by the Supreme Court. Now, second category of laws which can be tested under Article 13 Clause 1 and 13 Clause 2 are Constitution and constitutional amendments. You see, till date, 103 constitutional amendments have been carried in Constitution of India till 14th January 2019. And 24th constitutional amendment, which changed the heading of Article 368 as power of Parliament to amend the Constitution and procedure thereof. And by this amendment, Article 368 Clause 3 and 13 Clause 4 were added in the Constitution. Similarly, Clause 4 and 5 were added in Article 368 by 42nd Constitutional Amendment Act of 1976. But these two clauses were struck down in Minerva Mill Limited versus Union of India. So this is an example where constitutional amendment was declared unconstitutional by the Supreme Court. Similarly, Article 31 capital C was added by 25th Constitutional Amendment Act 1971, and later portion of this article was struck down in Keshwanand Bharati versus State of Kerala, an important leading case. Then you see the latest example is entire National Judicial Appointment Commission Act 2014 and 99th Constitutional Amendment Act, which added Article 124 capital A in the Constitution, was struck down by the Supreme Court. This enactment sought to replace the collegium system of judicial appointments with National Judicial Appointment Commission. Whole of the act was declared as unconstitutional by the Supreme Court in Advocate on Record Association versus Union of India as violative of basic structure of Constitution of India. Since judicial primacy is a part of basic structure of our Constitution. So dear students, you have seen that the language of Article 13 lays down supremacy of fundamental rights over any other law in case of inconsistency between the two. Thus, pre-constitutional laws will be declared invalid under Article 13 Clause 1. That means the pre-constitutional laws under Article 13 Clause 1 shall be invalid only to the extent they fall within these categories of laws in force. Laws in force means the laws which were in force at the time of commencement of our Constitution. But uncodified personal laws of Hindu, Muslim, and Christians, they do not fall in this category. And they cannot be declared invalid on this ground that they violate fundamental rights. But now of late you have seen that the custom prevailing in Muslim communities relating to triple talaq has been declared unconstitutional recently by the Supreme Court. So Article 13 Clause 1 deals with existing laws as they stood immediately before the commencement of Constitution. In other words, Article 13 Clause 1 deals with pre-constitutional laws or existing laws, that is, laws which were in force immediately before the commencement of Constitution of India. Under Article 13 Clause 1, all laws in force, insofar as they are inconsistent with fundamental rights, shall, to the extent of inconsistency, become void with effect from 26 January 1950. But they become void only after the court holds them inconsistent with fundamental rights. So long the courts do not hold them to be so void, they shall continue to remain in force. Of course, declaration from the court is required. So, in applying the rule of Article 13, Clause 1, following principles of interpretation should be kept in mind. Number 1, no retrospective effect. The provisions of Constitution of India relating to fundamental rights have no retrospective effect. All inconsistent laws, therefore, become void with effect from 26 January 1950. But acts done before the commencement of Constitution of India in pursuance of or in contravention of provisions of any law which after 26 January 1950 become void because of inconsistency with fundamental rights are not affected. Meaning thereby, Article 13 Clause 1 is totally prospective in its operation. But dear students, you must note down that inconsistent laws, they are not wiped out so far as past transactions are concerned. If something happened before commencement of Constitution of India, which violates fundamental rights, then that transaction remains valid. Here is an illustration before you. Keshav Madhav Menon versus State of Bombay. In this case, proceedings were started against Madhav Menon for an offence under Section 18 of Press Emergency Powers Act 1931 in respect of a pamphlet published in 1949. I have highlighted the word 1949 in red color just to show that this offence was committed prior to commencement of Constitution of India. It was contended on behalf of the appellant that the act was inconsistent with fundamental rights of freedom of speech conferred by Constitution, and therefore it had become void under Article 13 after 26 January 1950. Hence, the proceedings against him could not be continued. Supreme Court rejected this contention and decided that Article 13 Clause 1 has no retrospective effect. Such laws existing for all past transactions and for enforcing all rights and liabilities accrued before 26 January 1950. So this article has no retrospective operation. Then second rule of interpretation, dear students, which you have to keep in mind is the rule of severability. Article 13 does not make entire act inoperative. It makes inoperative only such provisions of it as are inconsistent with or violative of fundamental rights. Sometimes valid and invalid portions of the act are so interweaved that they cannot be separated from each other. In such cases, invalidity of the portion must result in the invalidity of the act in its entirety if they cannot be separated. Reason is that what remains valid is so inextricably bound up with the part declared invalid that the valid part cannot survive independently. In determining whether valid part of a statute are severable from invalid parts, the intention of the legislature is the determining factor. Now, what is the test? Whether the valid portion and invalid portions can stand together or not. So, test, dear students, is whether the legislature would have enacted at all that which survives without enacting part being found ultra-virus? If the answer is yes, then the remaining act may be allowed to stand. If answer is no, then whole of the act has to go. The severable invalid portion may be struck down not only to restrict but also to enlarge the application of the law if such arrangement will save the law. Here is another example, State of Bombay versus FN Balsar, decided way back in 1951 by the Supreme Court. In this case, 8 sections of Bombay Prohibition Act 1949 were held ultra virus on the ground that they infringe fundamental rights of the citizens. But the whole of the act minus these 8 sections were allowed to stand. They were perfectly severable from the remaining act. You can equate this position with a portion of a body having septic is being separated by the surgeon, but the remaining body survives as it is. If you have a septic in your leg, it can be operated by the surgeon, but that does not mean the whole body has to go. Whole body and that septic can be separated. Rule of severability says that only invalid portion of the law should go. The remaining act should be allowed to stand as it is. So dear students, this is all about justifiability of fundamental rights. In nutshell, Article 13, Clause 1 and Clause 2 are the two touchstones on the basis of which we will test the validity of pre-constitutional as well as post-constitutional laws, and we will see whether the previous law or current law is violating the fundamental rights or not. This shows how important our fundamental rights are. You see the importance given to fundamental right, justifiability given to the fundamental rights by our own constitution. Thank you, dear students. Thank you.